It was morning in Manhattan. The marble corridors of the Southern District Courthouse buzzed with anticipation. In room 1103, Judge Annalisa Torres settled into the bench, her robe still crisp after last night's decision. Today, the world waited to hear whether Ripple and the SEC, unusual bedfellows, could erase a multi-year verdict with a handshake deal. Months earlier, Ripple's general counsel had drafted a bold settlement: pay $50 million, reduce the original $125 million penalty, and lift the sweeping permanent injunction preventing institutional XRP sales. It was strategic, expedient, and the SEC had agreed, citing its evolving crypto policy. But the deal was incomplete without judicial blessing. Now both sides stood shoulder to shoulder before Judge Torres. The U.S. Attorney's seat was empty. The SEC filed its papers ex cathedra. Counsel for Ripple, calm yet resolute, urged, "Your Honor, this is in everyone's interest. Market stability, corporate clarity, regulatory harmony." Even so, the judge remained silent, unreadable. As the gavel hit, the motion was clear: denied. Torres's voice echoed through the room, firm and unyielding. She rebuked both parties. "You do not have the authority to override a final judgment made under an act of Congress," she said, citing weighty Supreme Court precedents. She pressed the gravity of the $125 million judgment and injunction, the institutional XRP sales violation. Private consent, she warned, could never eclipse public law. The ripple effect was immediate. Counsel for Ripple exchanged controlled nods. The SEC representatives tucked away their tablets, expression unreadable. A hush fell, even the cameras paused. Outside, Ethereum traders on Wall Street stared at their screens. XRP had dipped 3% on the news. Market watchers muttered about regulatory resilience and the chilling effect on other crypto companies. A Reuters headline flashed: "Judge says both sides cannot escape permanent injunction." In the press room, journalists scribbled furiously. "No exceptional circumstances," one typed. Another referenced institutional and retail sales. Distinctions. Torres A.S. pivotal summary judgment from July 2023 had quietly delineated that XRP on public exchanges was not a security, but the $728 million in institutional sales had been deemed unregistered securities. That dichotomy remained legally binding. Ripple's chief legal officer, Stuart Alderoty, later posted on X, "The company has not decided its next steps. Could they withdraw the appeal or march onward to the Second Circuit?" In the waning afternoon sun, lawyers packed their briefcases. The settlement whim lay in ruins. Yet the courtroom S decision, rooted in public interest and legal consistency, illuminated a powerful truth. Even in a world where crypto evolves faster than statutes, the final word of a judge can still bend destinies. As reporters filtered out, one phrase lingered: "Only an appeal can now alter this." The months ahead promised more motion papers, more appeals, more court dates. In New York, the last chapter had not closed, it was simply turning its page. And its dramatic retelling draws on today's real ruling. Judge Torres denied the joint motion to vacate the injunction and reduce the penalty, underscoring that private agreement cannot set aside final judgments under Congress's laws.